Welcome to the deep dive. You bring the sources, the articles, the research, the court documents, whatever you've got, and we dive in head first. Our job is to, try and make sense of it all, cut through the noise, and help you get informed quickly and properly.
And hopefully find some interesting angles along the way.
Absolutely. In this deep dive, we're tackling a fascinating bundle you sent over. We've got news articles, some background research, and really crucially, the actual court documents from a pretty significant legal clash. It's all about Australian electoral law, recently decided. Our mission today, to untangle what feels a bit like a political mystery, maybe even a procedural thriller.
Yeah, it's got elements of that. You've got a political party that kind of vanished from the official register, then a pretty dramatic attempt to reappear just before an election. And it all leads to this high-stakes legal showdown, really questioning the rules around who gets their name on the ballot paper. It has implications for, well, how our democracy works procedurally.
That's the core of it, isn't it? We're looking at Babet and Palmer v. Commonwealth, a high court case, fresh off the docket.
That's the one. And the central question really is, what happens when a political party deregisters itself, tries to pop back up later, but the law says, hold on, not so fast.
It's a story about, strategy, political ambition, and how they run up against the hard, cold rules of the Electoral Act. Let's start by setting the scene. Who are the main players here, our sort of dramatis personae?
Right. Gotta know the cast. First up, a name most people in Australia will know, Clive Palmer, billionaire, businessman, sort of perennial figure in politics, sometimes in, sometimes out, often funding things. Here, he's key because he owns the trademarks for the United Australia Party, the UAP. And he was a plaintiff, the main person bringing the second legal case to the High Court. His resources, his profile, it definitely signals this was going to be a serious fight. High stakes from the get-go.
Okay, Palmer. Then there's the person actually flying the UAP flag in Parliament House.
Yep, Senator Ralph Babet, elected to the Senate for the UAP in 2022. His term runs quite a while, until 2028, so he's the party's sitting member in the Senate. And he was the lead plaintiff, the first name on the papers, and the main legal challenge. His personal stake is obvious. He needs his party registered to effectively operate, endorse candidates, the whole lot.
Makes sense. And working with Senator Babet.
That was Neil Favager. He's the national director of the UAP, so think operational leadership. He was the second plaintiff alongside Senator Babet in that primary proceeding. His involvement really highlights the practical side. He's the one who would have dealt with the Electoral Commission, trying to get the party re-registered, potentially becoming the registered officer if they had succeeded.
Got it. Palmer, Babet, Favager, and then the entity itself.
The United Australia Party, UAP. The sources are clear. It was a registered political party under Part 11 of the Commonwealth Electoral Act, not a newcomer. They ran candidates in 2019, again in 2022, for both the House of Reps and the Senate. So, they're an established part of the recent electoral landscape.
Right. So, established party, sitting senator, which makes the next part even more intriguing, the Vanishing Act.
Exactly. This is the first big twist. Sometime after that 2022 election, the UAP makes this pretty significant decision. They voluntarily deregistered, used a specific bit of the Electoral Act, Section 135, subsection 1, to basically ask the AEC, take us off the list.
Okay, hang on. Let's unpack that. Why? Why would a party, especially one that just got a senator elected, want to disappear from the official register? It feels backwards.
It does seem counterintuitive, doesn't it? To understand the why, you need to look at what registration under Part XIG actually gets you and what it costs you. The benefits are really substantial. You become eligible for public election funding, potentially millions of dollars depending on your vote share. Nominating candidates is way easier, less paperwork. But probably the biggest one, especially for voters interacting with the ballot paper, is you get your party's name, abbreviation, even the logo printed right there next to your candidates.
Right, the ballot paper branding. Crucial, especially above the line in the Senate.
Absolutely critical. Voters can just put one above the line for your party group. Huge advantage. So those are the benefits they walked away from.
So what was the trade-off? What were the obligations they might have been trying to avoid?
That's where Part XX, Division 5A of the Act comes in. It imposes pretty hefty annual disclosure requirements. Registered parties and their associated entities have to file detailed financial returns every year. They need to declare significant donations, who gave them money above a certain threshold. They have to detail their expenditure. It's all about financial transparency. These returns are public documents.
Okay. So registration means scrutiny.
Intense scrutiny. And the sources we have point pretty strongly towards this being the motivation. One source specifically suggests the voluntary deregistration was about, and I'm quoting here, shedding its donor disclosure obligations in the process. See, once you deregister voluntarily under 135, you generally fall out of that specific annual reporting regime for registered parties. It could mean less public information about who's funding you, at least for a while. Potentially, it could even affect rules around foreign donations if the party doesn't meet other definitions, like being a significant third party. So it looks like a strategic trade. Give up the ballot paper benefits temporarily to gain a period of, let's say, reduced financial transparency.
A calculated risk then.
Yeah.
Less transparency now, maybe planning to jump back in later. But as you said, the story didn't quite play out smoothly. What happened next?
Right. So they're off the register. Fast forward about 18 months. November 29th, 2024. Senator Babet makes the move. He lodges an application with the AEC, the goal. Re-register the United Australia Party, get back on the books, ready for the next federal election, which everyone expected sometime in 2025, get that name back on the ballot. Mr. Favager was lined up to be the registered officer again.
The comeback attempt. But it hit a roadblock.
A brick wall, really. The AEC denied the application pretty much straight away.
Why? What stopped them?
The denial wasn't discretionary. It was based on the direct operation of another part of the Act, Section 135, subsection 3.
Okay, this is the key section, isn't it? 135.3. This is where the law itself just slammed the door shut. What does it actually say?
It's pretty blunt. Section 135.3 states, effectively, if a party deregisters voluntarily under subsection 1, which the UAP did, then that party is ineligible to register again until after the next general election following that deregistration.
Wow. Okay, break that down. They deregistered after the 2022 election. So subsection 3 kicks in and says, you can't get back on the register until after the next election, the 2025 one.
Precisely. It imposes a mandatory waiting period, a lockout period. They were statutorily barred from re-registering before the 2025 election cycle was completely over, which meant no access to any of those registration benefits we talked about, the funding, the easier nominations, and crucially, no party name, no logo, no abbreviation on the ballot paper for that entire election.
So their own choice to deregister triggered a legal consequence that blocked their planned return, a major blow to their election plans.
Huge, not just an administrative issue, a fundamental legal barrier to appearing on the ballot paper as the UAP.
And when you hit a wall like that, based on the law itself, well, I guess there's only one place to go.
Straight to the High Court. Faced with this undeniable statutory block, the only option was to argue that the law itself, Section 135.3, was unconstitutional and therefore invalid.
So they geared up for a fight.
Yeah.
When did they launch the challenge?
Very quickly. The re-registration was denied around late November 2024. By December 12, 2024, they'd filed writs of summons, commencing proceedings directly in the High Court's original jurisdiction.
Bypassing lower courts, straight to the top. And you mentioned 2 proceedings.
That's right. File number B732024 covered both. The first proceeding had Senator Babet and Neil Favager as plaintiffs representing the party structure and leadership directly hit by the registration block. The second proceeding was brought just by Clive Palmer, focused more on his role as the owner of the UAP trademarks, arguing his rights related to using those marks were affected because the party couldn't get registered to put them on the ballot.
But the core argument in both was the same.
Yes, that Section 135.3, the lockout provision, was invalid because it clashed with fundamental principles in the Australian Constitution.
Trying to strike down a law passed by the federal parliament, that's always a massive legal undertaking, a real constitutional showdown. Who was spearheading the legal arguments for Palmer, Babet, and Favager in the High Court?
Their solicitor on record was Sam Iskander from Alexander Law. They briefed senior counsel Dominic Villa SC to argue the case before the full bench of 7 High Court justices.
Villa SC, a well-known name in public law circles.
Indeed. He had the task of convincing the court that this particular subsection, 135.3, went beyond Parliament's constitutional power. The hearing itself was on February 7, 2025.
Okay, let's get into the legal trenches. What were Villa's main lines of attack? What were the constitutional arguments they put forward?
They came at it from a few angles. The first major argument was grounded in Sections 7 and 24 of the Constitution. These are the sections that say our senators and members of the House of Reps must be directly chosen by the people. The plaintiff's argument was that Section 135.3 interfered with this. How? By preventing the UAP name and logo from appearing on the ballot paper. They argued this hampered the ability of voters to make a fully informed choice. They really emphasized the unique status of the ballot paper. Villa argued, according to the material, that the law ignored the privileged position of the ballot paper as, quote, the last piece of information which a voter receives before casting his or her vote.
That makes intuitive sense, doesn't it? Whatever advertising or campaigning happens before, the ballot paper is that final moment of decision. Seeing the party name there helps identify the candidate.
That was exactly their point. And they pushed back against the idea that other forms of communication, how to vote cards, ads, rallies were enough. They said being able to identify the party on the ballot itself was distinct and critical. Other communication methods were, in their words, beside the point when assessing the impact on informed choice right at the polling booth. And they argued this restriction wasn't justified. It wasn't a reasonable limitation on that directly chosen requirement.
Okay, so argument one. It hinders informed choice by keeping key info off the ballot. What was the second line of attack?
Argument two invoked the implied freedom of political communication. This isn't written explicitly in the Constitution, but the High Court has long recognized it's implied by the system of representative government the Constitution sets up. The idea is for people to make informed choices in elections and participate in democracy, there needs to be a reasonably free flow of political discussion and information.
Right. And they argued that keeping the UAP name off the ballot restricted that flow of political information, prevented communication about party affiliation right where it counts.
Exactly. But this argument immediately ran into a major obstacle existing High Court precedent.
Ah, yes, you mentioned this earlier, the Mulholland case.
Precisely. Mulholland v. Australian Electoral Commission from 2004, and it was affirmed quite recently in Ruddock v. the Commonwealth in 2022. The Commonwealth's defense relied heavily on these. In Mulholland, the High Court majority basically said, the right to have your party name printed on the ballot paper is not a pre-existing constitutional right or freedom. It's a statutory entitlement, something created by the Electoral Act itself. Therefore, the conditions the Act puts on getting that entitlement, like Section 135(3), don't burden the implied freedom. They just define the scope of the statutory gift, if you like. They set the rules for when you qualify for it.
So the freedom of political communication exists independently, but having your name on the ballot doesn't. It's just a privilege granted by the law on the law's terms.
That was the essence of the Mulholland reasoning and the Commonwealth's argument here. Villa SC knew he had to tackle this head-on. He argued Mulholland should be reconsidered, perhaps even overturned or at least distinguished. He argued that focusing on whether the right exists independently of the statute was, quote, a distraction from what matters in real-world political communication. He urged the court to look at the practical effect. Does the law impede communication compared to a situation without the law? He cited more recent implied freedom cases like Brown, Liberty Works, Farm Transparency to support this practical effect approach. He even tried to argue Section 135(3) was severable, that the court could strike it down without affecting the other parts of the Act that grant the ballot paper entitlement in the first place.
A bold move, trying to get the court to revisit established precedent. What about the fact the UAP, chose to deregister? Didn't the Commonwealth just say, you brought this on yourselves?
Oh, absolutely. That was a central plank of the Commonwealth's defense. This was a self-inflicted wound, as their counsel put it. The plaintiffs, through Villa, pushed back hard on this. They argued that, yes, the voluntary deregistration was a casual factor, but it didn't negate the constitutional burden imposed by Section 135(3) itself. The law was still operating to restrict them. They used an analogy to the Roe case concerning voter enrollment deadlines. The fact people could have enrolled earlier didn't save a law that later shut the door too early. The focus, they argued, should be on the law's effect now, not the party's past choices.
Interesting analogy. Okay, informed choice, implied freedom. What was the third main constitutional argument?
The third argument was that Section 135(3) resulted in constitutionally impermissible discrimination. They argued it unfairly discriminated against candidates associated with voluntarily deregistered parties, especially a party like the UAP with a sitting senator. They suggested that underlying Sections 7 and 24, the directly chosen provisions, is a principle or value of political equality. And this principle limits Parliament's power to create laws that treat different political players unfairly, disadvantaging some in their ability to participate as candidates or electors. Villa explained this to Chief Justice Gagler during the hearing. He said the discrimination argument was essentially shorthand for differential treatment that either disadvantages one or advantages another. He acknowledged it boiled down to whether that differential treatment was constitutionally justified. And their contention was that, particularly for a parliamentary party like UAP, this discrimination, this differential treatment, was not reasonably appropriate and adapted to achieving any legitimate constitutional purpose.
So 3 big constitutional arguments: hinders informed choice, restricts political communication, and imposes unfair discrimination. That's a significant challenge. And let's flip to the defense. How did the Commonwealth respond? Who argued their case?
The Commonwealth's defense was marshaled by the Australian Government Solicitor's Office, with Daniel Gatehouse mentioned in the materials. But leading the arguments in court was the Commonwealth's top lawyer, the Solicitor General, Dr. Stephen Donoghue, KC.
The Solicitor General himself. So the government took this very seriously.
Absolutely. Dr. Donoghue was assisted by junior counsel Brendan Lim and Christine Ernst. Their job was to defend the validity of Section 135(3).
What was the core of Dr. Donoghue's defense? How did he counter those 3 main arguments?
The absolute cornerstone of the Commonwealth's case, especially against the implied freedom and informed choice arguments, was this. Section 135(3) does not burden any constitutional right or freedom, full stop. They stood firmly on the ground established by Mulholland and Ruddock. Their argument was elegantly simple, in a way. The ability to have your party name on the ballot paper. It's not some fundamental right found in the ether of the Constitution. It is purely 100% a statutory entitlement. It exists only because the Electoral Act, in sections like 214 and 214A, says it exists, and they hammered that Mulholland principle. To show a constitutional burden, the plaintiff needs proof that the challenged law burdens a freedom that exists independently of that law, end quote. The Commonwealth argued Section 135(3) doesn't do that. It's simply one of the conditions Parliament has attached to accessing the statutory entitlement. The conditions define the entitlement, they don't burden something separate from it. You can't claim the benefit while ignoring the conditions.
So the rules of the game include this waiting period if you choose to deregister. You chose to deregister, so you accept the waiting period.
Precisely. That's where Dr. Donoghue used that memorable phrase. A self-inflicted wound is not a constitutional injury. It perfectly captured their stance. The UAP's problem wasn't caused by an unconstitutional law, but by the foreseeable consequence of their own voluntary action under a valid statutory scheme. When Justice Edelman queried if the entitlement was conditional, Donoghue agreed it's offered conditionally as part of a package. And they strongly resisted the call to reopen Mulholland, arguing it provided vital clarity and wasn't a mere distraction.
That's a very clear line. But what about the purpose of Section 135(3)? Why did the Commonwealth say this law exists? If it's not just arbitrary, what's its function?
They argued the plaintiff's view of the purpose was far too narrow. It wasn't just about stopping parties dodging compulsory deregistration. The main game, according to the Commonwealth, was promoting transparency and protecting the integrity of the whole party registration system. How does it promote transparency? By creating a significant disincentive the lockout period against parties deregistering just to duck out of those annual financial disclosure obligations. Remember, deregistration could allow a party to operate with less scrutiny on its funding sources for a while. Section 135(3) makes that strategy costly because the price is losing ballot access at the next election. And this protects the scheme's integrity, they argued, by ensuring a quid pro quo. If you want the benefits of registration, like ballot access, you generally need to have been playing by the rules, including the disclosure rules during the lead-up period, the preceding electoral cycle. Dr. Donoghue summed up the purpose neatly. It's to condition the re-registration of a political party that has voluntarily deregistered and thus has not been subject to the obligations of a registered political party during an electoral cycle, pending completion of the relevant electoral cycle. And critically, they argued this transparency purpose isn't just compatible with our system of representative government, it actively, affirmatively promotes it. Voters need that financial information to make informed choices.
Okay, so the law links the benefit, ballot access, to the responsibility, transparency, and penalizes breaking that link. What if the court did find there was some kind of burden on a constitutional right? Did the Commonwealth have a fallback?
Yes, the standard second stage of the test. Even if a burden was found, they argued Section 135(3) is still valid because it's reasonably appropriate and adapted to achieving those legitimate purposes, transparency and integrity. They argued it's suitable, there's a clear rational connection between the lockout period and deterring avoidance of disclosure, and they argued it was necessary in the proportionality sense, meaning there wasn't an obvious, compelling, and equally effective alternative that was less restrictive. They specifically tackled the plaintiff's suggestion of just requiring retrospective disclosure upon re-registration. The Commonwealth said, no, that's not as good. Timely, continuous annual disclosure is much more valuable for transparency than a data dump just before an election. election. They also invoked Justice Stewart's point from the Ruddock case about courts showing some deference to Parliament on electoral machinery laws. These laws should only be struck down if they're really extreme, offending the most essential of democratic values. Section 135.3, they argued, clearly wasn't in that category.
Right, it's just part of the regulatory plumbing, designed for a good reason. And the discrimination argument. How did the Commonwealth counter that?
They rejected it fundamentally. First, they argued there's no separate freestanding constitutional rule against discrimination between political parties. Discrimination only matters, they said, if a law already burdens the right to vote, choose 7-4, or the implied freedom, and then only as a factor in assessing if the law is justified or proportional, as they put it in their submissions. Absent such a burden, discrimination is not a distinct ground of invalidity. Second, even if discrimination were relevant, they argued 135 doesn't discriminate unfairly. It doesn't target parties based on their political views, their size, or their success. The trigger for the differential treatment the legislative discriminant is simply the voluntary act of deregistering. Any party, big or small, left or right, that chooses to do that faces the same consequence.
So the Commonwealth's case in a nutshell. No constitutional right burdened here, just conditions on a statutory benefit. Even if there was a burden, the law is a reasonable and proportionate way to achieve vital transparency goals. And the discrimination argument doesn't stand up on its own.
That's a very good summary of their position.
This all played out in the High Court hearing on February 7, 2025. You mentioned the justices were asking tough questions. What insights do the sources give us about those exchanges? What were the judges focusing on?
The sources highlight a few key interactions. Justices Jagot and Gleeson, for instance, were apparently quite focused on the why. They pressed Mr. Villa on the UAP's unexplained motives for voluntarily deregistering in the first place.
So they were interested in the strategic choice behind it all.
It seems so. It suggests they saw the party's own actions as highly relevant context for the legal consequences that followed. Chief Justice Gageler engaged with Villa on the discrimination point, probing whether it was really distinct from the informed choice argument and whether it all just came back to justifying the differential treatment. And the issue of choice, of voluntariness, kept coming up. Justice Gordon specifically asked Villa to grapple with the Commonwealth's point that this was self-inflicted due to voluntary deregistration. Justice Stewart then followed up, reportedly asking something like, why isn't Section 135 also a choice that the UAP could make or not make?
Those questions really cut to the core issues, don't they? The link between the party's actions and the law's effect, the nature of the constitutional burden, and the justification for the law.
Absolutely. They show the court testing the foundations of each side's argument.
Okay, so the arguments were heard, the justices grilled the lawyers, then the wait for the judgment. Not a long wait in this case.
No, remarkably quick turnaround for a constitutional case. The hearing was February 7th. The judgment came down on February 12th, 2025, just 5 days later.
And the verdict?
Decisive. The High Court held unanimously that Section 135 of the Commonwealth Electoral Act is valid.
Unanimous. All 7 justices agreed. That sends a pretty strong message. What did that mean for Babet, Favager, and Palmer's case?
It meant complete defeat. The court formally answered no to the 3 constitutional questions posed. Is Section 135.3 invalid because it infringes the directly chosen requirement? No. Is it invalid for impermissible discrimination? No. Is it invalid for infringing the implied freedom of political communication? No. Consequently, no relief was granted, the law stood, and their challenge failed on all fronts.
So why? What was the core reasoning that led all 7 justices to uphold this law? How did they deal with the plaintiffs' arguments in the end?
Looking across the different judgments, there was strong convergence. On the directly chosen by the people argument, the court found Section 135.3 didn't breach this requirement. They viewed it as established machinery provision, applicable to all parties, and importantly triggered only by the party's own choice to deregister. Crucially, they accepted the Commonwealth's argument about the law's purpose. Chief Justice Gageler and Justice Jagot, with Justice Edelman agreeing on this point, found the section was reasonably appropriate and adapted to serving a transparency purpose. And they stated this purpose not only is compatible with the constitutionally prescribed system of representative government, but affirmatively promotes it. Promoting transparency was seen as a good thing for informed choice.
So they bought the transparency argument. What about the implied freedom challenge? How did they get past the plaintiff's attempt to distinguish or reopen Mulholland?
They didn't get past it. They met it head-on and reaffirmed it. The court decisively rejected the implied freedom challenge by applying the established principle from Mulholland and Ruddock. Justices Gordon, Stewart, Beach-Jones, and others effectively said, The burden, the plaintiffs complain about not having the UAP name on the ballot, only exists because of a statutory entitlement created by the Electoral Act. Section 135(3) is simply one of the conditions defining when you get that entitlement. It doesn't burden some independent, pre-existing right to political communication in the relevant sense. The court saw no reason to depart from Mulholland. The power of Parliament to set the conditions for accessing these kinds of statutory electoral benefits was strongly upheld. Justice Edelman's judgment also reinforced this, analyzing constitutional implications and finding the claimed rights here weren't sufficiently grounded or necessary to invalidate the law.
Okay, Mulholland stands firm. And the discrimination argument, why did that fail unanimously too?
The court found no basis for it. They essentially said the plaintiffs hadn't shown why it was logically or practically necessary to create a new implied constitutional principle, specifically prohibiting this kind of discrimination between categories of political parties. They concluded that the existing constitutional framework, the directly chosen rule, the implied freedom, properly understood, was sufficient to protect representative government. They didn't see a need for or basis for a separate, freestanding constitutional principle of non-discrimination. Again, they accepted the differential treatment wasn't based on impermissible grounds like political viewpoint, but on the party's voluntary action under the statute, and it was justified by the legitimate transparency purpose.
So across the board, the court accepted the law's legitimate purpose, transparency, integrity, and found it was a reasonable way to achieve it, without infringing core constitutional rights or principles.
That's the essence of it. They saw the law as part of the necessary machinery for regulating political parties in a transparent way.
And the practical consequences. Costs followed the event.
Yes, standard practice. The unsuccessful parties, Senator Babet, Mr. Favager, and Mr. Palmer, were ordered to pay the Commonwealth's legal costs, which would have been substantial for a high court constitutional challenge.
A costly loss, then, in more ways than one. What did this mean immediately for the UAP's election plans?
The immediate consequence was crystal clear. No UAP on the ballot paper for the next federal election. They were legally barred from re-registering under that name until after the election concluded. Whatever candidates they might run would have to run either as independents or under a different banner.
And did we see a different banner emerge? What was Palmer's response?
Well, the sources report a very swift pivot. Apparently, within just weeks of the High Court judgment, Clive Palmer had unveiled a hastily branded Trumpet of Patriots Party.
Trumpet of Patriots Party.
Okay.
So, if the UAP door is closed, try opening a new door with a new name.
That certainly seems to be the strategy suggested by that report. It highlights just how critical that official party registration and ballot paper identification is considered to be for electoral campaigning. If you can't use one name, you might try to register another.
It really underscores the significance of these registration rules. What are the broader takeaways from this whole saga? What does this case tell us about Australian electoral law and politics?
I think it firmly reinforces the Parliament's power to design the electoral system as an integrated package. Since the big reforms back in 1984, there's been this linkage between the benefits parties get public funding, easier nomination, ballot access, and the obligations they have, particularly around financial disclosure. This Babet and Palmer decision gives the High Court's unanimous stamp of approval to laws designed to protect that linkage. Section 135(3) was seen as a crucial part of that architecture, deterring parties from trying to game the system by opting out of transparency obligations while still hoping to easily regain the benefits later. The court essentially backed the idea that transparency is a legitimate, even necessary condition for receiving the significant advantages of registered party status. It also solidified that Mulholland principle regarding statutory entitlements versus independent constitutional rights, particularly for the implied freedom.
It's a clear signal that playing by the rules, including the transparency rules, is expected if you want the privileges the system offers. And the High Court will back Parliament in enforcing that, provided the rules serve a legitimate purpose.
Exactly. It wasn't seen as the law unfairly burdening the UAP, but as the UAP facing the predictable consequences of choices made within a system whose rules were constitutionally sound.
So, wrapping this deep dive up, it seems the central tension was between a party's desire to be identified on the ballot and the system's requirement for ongoing transparency. Where does this leave us?
Well, it leaves us with the law upheld and the UAP off the ballot for the next election under that name. But it also leaves us with that interesting strategic response, the emergence of a new party name.
Which brings us to our final thought for you to chew on. This case really put the spotlight on that balance. A party's need for identification versus the public's need for transparency about who funds politics. Did the High Court get that balance right here in affirming that the law linking ballot access to continuous registration and disclosure is valid? Does our current system overall strike the right balance? And thinking about that trumpet of Patriots Party, how might savvy political operators continue to navigate or maybe even seek to change these rules in the future? What's the next move in this ongoing interplay between electoral law and political strategy? Lots to think about there. Thank you for joining us for this deep dive into Babet and Palmer v. Commonwealth. We hope untangling the Vanishing Act, the attempted comeback, and the constitutional showdown has given you a clearer picture of how these crucial electoral rules work and why they matter.